And we're live.
Are we live?
We are.
Well, we're going to start again.
No, this sort of thing the audience loves.
Well, hello everyone, and welcome to this, the latest in Practico's Costs Chats Between Friends. For those of you who aren't familiar with the format, it's not so much a formal lecture on cost development, but a discussion led by our guest, in which the other two members of the group participate and offer their two penn'orth. Today we are delighted to welcome as our guest Ben Williams QC, who's not only an old costs friend, but also a cost silk at the very top of his game. And talking to him will be, as usual, Andy Ellis, the Managing Director of Practico, and myself, Jeremy Morgan, retired cost silk and consultant to Practico. Just a brief housekeeping point. There will be an email summarizing the discussion and including case references or links sent out afterwards. So you don't need to take detailed notes if that's what you would otherwise be doing. The recording will also be available on YouTube and as a podcast on the usual sites. We're going to be discussing three areas in particular, and maybe one more if time permits. The three areas we were thinking of discussing are guideline hourly rates to look at where we are in the light of last year's increases, a review of the situation in relation to damages-based agreements where no legislative changes have been made, but one or two other developments have taken place. And finally, a look at group litigation, particularly in the light of the Supreme Court's decision in Lloyd and Google. Just to show though, and you'll forgive the pun, that there are no debts to which we will not sink, I'm going to invite Ben in the course of the discussion, and I haven't warned him about this, to get in seamlessly a reference to Davy Jones's locker. Over to you then, Ben, on guideline hourly rates.
Well, good morning, and thank you for inviting me again. It's lovely to see you both, and I hope it can be an informative discussion for the masses who are waiting on our words. So yes, guideline hourly rates, I think that is a useful starting point. And I think the most interesting thing about guideline hourly rates really is the effect that last year's review has had in broadening or potentially broadening their application into areas where previously, if attention was paid to them at all, it was usually attention was paid only for the purposes of dismissing them, by which I really mean some quality commercial work, City of London work, or its equivalent in the business districts of the other big cities. Because for years, really, guideline rates, as we know, they haven't been updated since 2010, even before the recent sort of post-COVID and Ukraine inflation. I mean, between 2010 and 2020, I think inflation, depending on how you measured it, RPI or CPI, had gone up sort of 20 to 30%. So they were long outdated. And the only areas really where they seem to be applied quite frequently was in the context of routine county court litigation, particularly personal injury litigation. And for years, the personal injury practitioners understandably pointed out, well, you know, we have to pay our staff more, we have to pay our landlords more, shouldn't we be getting higher rates? But because of the fairly negative attitude towards the claimant PI industry, which there seems to be in recent years, they were given pretty short shrift. But finally, of course, we get Sir Stephen Stewart and his working party reviewing hourly rates, and they overhaul them and update them quite substantially this last summer. And what we now suddenly see are the hourly rates are beginning to be taken seriously again across the board. And we're particularly beginning to see hourly rates at guideline levels being applied in commercial cases, which does come as a pretty rude shock, I think, particularly to firms who are, you know, in or at the threshold of the magic circle. Because, you know, even the rates as updated really do seem to be an awfully long way from what the magic circle and their close competitors are actually charging. And so, you know, one is beginning to see judgments coming through where the rates of commercial solicitors are being reduced very substantially. You know, I mean, certainly in my experience, it's unusual to see partners in the top city law firms charging significantly less than £600 an hour. It's perfectly routine to see £700 or £800 an hour. And some of the American firms in particular, you may see figures of £900 an hour. Sometimes even it's commonly, if you're actually using New York firms and with a dollar exchange rate, some of those are even clearing £1,000 an hour once it's converted to sterling. But the guideline hourly rate, even as updated, is much less than that, 512, I think. I'll be corrected if I'm wrong. I stupidly didn't have them in front of me. But on any view, we're talking about quite significant, very significant deductions. And there's been a recent decision of the Court of Appeal in a competition case, Samsung, involving Samsung and LG, wrangling about the market in which they're both sort of so well known. In which the Court of Appeal has said quite clearly that if you want more than guideline rates, even in a sort of heavy commercial case, you're going to need to make a strong case for it. And I suspect that will come as a fairly rude shock to commercial clients, who probably feel, well, we are sort of big and ugly enough to look after ourselves. We go out into the market, we negotiate hard. At the end of the negotiation, this is the rate that we've emerged with. We couldn't have got it any lower if we wanted to go to the solicitors of our choice. And yet they're still told, oh no, it's going to be cut by 25%. Because it's above what a committee has said is the reasonable rate between the parties, and that as I say, I think it's going to come as quite startling to many in the world of city litigation.
Perhaps early days to work out what sort of factors will be taken into account in exercising discretion to increase the rates. And we know from decisions so far that simply saying we're a city firm or is a competition case or something like that is not enough. What do you think will be relevant factors for people to be putting forward if they're seriously trying to make out a case for higher rates?
Well, you're quite right, and just by way of background for people that don't follow this, the rates have specifically been said to include sort of heavy city type work. And in fact, one of the differences in the rates as they now are is that so far as commercial work is concerned, although it is still called the London 1 band, in fact, the guidance makes it clear that really this is a sort of floating band that applies to high quality commercial and city type work wherever it's performed. And conversely, and as was the case under the old rules, if you happen to be in the City of London but you're not doing commercial work, you're not going to get London 1 band. So it's a band specifically really for heavier work with privately paying clients. And so it doesn't avail you to say, oh, well, we fall into this category, because that is the very category for which the guideline has been issued. And just before I come on to actually answer your question about what criteria do I think might be helpful, I think it probably is just worth saying there's something a little bit about how the guideline rates appear to have been reached in the first place, because what there doesn't really seem to have been, and in fairness to the powers that be, it's not easy to do because there's a lack of transparency, but there doesn't really seem to have been a serious inquiry into what rates are actually available out there in the market. And you can see why that might be the case in some areas, because in some areas there isn't really a market, like personal injury, for example, because clients are all acting on CFAs and they're not paying their own they're not paying their own fees, so they don't negotiate. But in the commercial world, obviously there is a market out there, and you would think that in the commercial court and so on, there would be enough summary assessments that there would at least be some data as to what rates are actually out there in the market. But there doesn't seem to be any investigation into that, and what we've really got are hourly rates which seem to be based really on an updating of 2010 hourly rates with reference to inflation and various other factors. And the 2010 hourly rates, even those weren't based on any sort of market examination either. And I think that that they are divorced from what is actually out there in the market. And yet the purpose of detailed assessment isn't meant to be to allow an arbitrary tariff as to what you can get between the parties, like a sort of variant of the fixed cost regime. It is meant to be a determination of what is a reasonable market rate. That is historically what detailed assessment has always been. So I think in some ways for the commercial world, and I think we can all agree that there aren't going to be many sort of newspapers or politicians out there shedding tears for people that can afford to instruct firms in the magic circle. But it does seem to me to be very arbitrary. The rates which are being set down are rates which are not necessarily divorced between rates which you can actually go out and negotiate in the market. Even if you're a big blue chip business as I said already, who's big and ugly and have to negotiate a pretty tough deal with your solicitor. The rates may simply not be out there. So I think it is quite an unusual starting point. And what I would be interested to see actually is not so much what the Court of Appeal is saying in cases like Samsung. We all know the Court of Appeal can be a pretty policy-driven court. I think what may be interesting to see is what do the judges at first instance in the commercial court and the other business and property courts who actually see these things, what will they say? Because I think they may very well say, well, I see summary assessment schedules day in, day out, and rates of £500 an hour simply are not available in the market if you want to go to a top firm. And so the real question is the case worthy of a top firm? And if it is worthy of a top firm, it's not unreasonable to get what a top firm charges. And I think it's probably right to say that the kind of revisitation of guideline rates and the final sort of crumbling of the dam, which had held the 2010 ones in place, partly did come because it was increasingly common for judges in the business and property courts. They went from a process which I've alluded to already of just quietly ignoring them to come 2019, 2020, there were a series of cases where judges actually said these rates are positively unhelpful. They completely fail to reflect the market. And we had Judge Hodge, for example, the commercial judge in Manchester, just applying a 35% uplift. So I think it's possible that there may be some pushback against these rates in commercial cases from the judges of first instance if they're persuaded they're simply out of sync with what's out there in the market. And of course, the current high inflation is something that might be used as a smokescreen, to allow them to start departing from the rates, even before they're formally revised. So that's the starting point. I think, however, unless until that process starts happening, then as you've rightly said, Jeremy, you can't just say, oh, it's a commercial case, blue chip, we're Herbert Smith or whoever we may be. This is what we charge. I think you are going to have a sort of rather granular process of saying, these are the factors that make it, exceptional, even as compared to commercial litigation. Obviously, you can continue to make the point that these are guidelines for summary assessment. So they're the sort of rates that would be allowed after, in general, sort of non-heavy applications in the commercial court on a Friday. So one can reasonably say, well, yeah, but in cases which are very document heavy, which go to trial, which go to long trials, there is a facility for there to be some significant uplift for care and conduct, particularly at the grade A and perhaps grade B end. And that's just a variant of the arguments that personal injury solicitors, as I've said already, have been wearily familiar with for more than a decade. Essentially singing for your supper to say this is what justifies a higher than guideline rate. And the commercial world has been rather insulated from that. But I think for inter partes assessment, they're probably going to have to start singing for their supper to some extent as well.
Yeah, I thank you, Ben. I agree with that. I think perhaps it was probably inevitable, but when these rates were introduced, what I think is a very sensible measure of taking geography out of it, certainly within London postcodes. Once you start looking at type of work rather than the postcode it's been worked in, then it's more likely to be seen as a rate for that type of work, and they will adhere more closely to the guidelines. But I mean, the example often given, obviously, is that it's just been an anomaly for many years that for the charts, one of the Magic Circle firms is in E14. It shares the same postcode as Poplar. But it was always a nonsense to suggest it would have the same hourly rates as a sort of a legal aid practice in Poplar High Street sort of stuff.
Yes, right.
And that was really something of a given. But some of these arguments remind me of in the old days when you would turn up in the House of Lords for a taxation. You try and put all sorts of arguments about why your case was special, then they just turn around and say, yeah, but all our cases are special. Why are you more special than everybody else that comes in? And it's a little bit like, well, why are you more special than every other big commercial firm that does all big complex cases?
Yes.
And in terms of what might take it out of the norm, I think there's been some suggestion that if there's a significant international element that may be the case, but I tend to see in those situations it probably tends to go more to the length and breadth of the dramatist persona in the case. They might, where large international firms will start to use connected offices in other European cities and the like, rather than it goes to which rate they should be applying. So I think we are going to be there are going to be significant arguments about this. And the only other point I would make is that in terms of giving frontline judges more experience of making them think about hourly rates, it's a bit of a shooting themselves in the foot when there's been decisions that specifically outlaw them from dealing with hourly rates on budget applications.
Yes, quite.
Particularly when you don't have to have a full hour's argument over it, do you? 10 minutes is ample.
One of the things I think that may also be interesting is, I've mostly been addressing from the perspective of the clients, but I suspect it will impact the law firms as well, because what I suspect is the client's expectation will remain what clients in the commercial world have always been told. If you win, probably expect to get 70% of your costs back. And I think, and of course, historically, clients have accepted that. I don't think clients are going to suddenly accept that because of changes to the guideline hourly rates, they're going to live in a world where they only get 50% of their costs back. I think they're still expect to get 70% of their costs back. And I imagine they will, in that case, start leaning on the firms of solicitors to say, well, hang on a second, if the court said your hourly rates are much too high, why, on any view, you should share the pain. Or arguably, you should absorb the whole of the pain because, you shouldn't have been charging me more than a reasonable rate. And the court's held that it's not reasonable. So I suspect that unless, as I say, the commercial court judges really start saying no, these rates are just not realistic for our sorts of work, they will potentially lead to tensions between solicitors and clients as well. And then, of course, you also do lead to the perverse situation that the solicitors may actually be better off if their clients lose, because if their clients lose, obviously they just have to pay. Because if their clients win and they only get 50% of their costs back, you may have a client that makes a complaint that a client that lost wouldn't have made. It's a sort of slightly through the looking glass scenario.
Indeed.
I think the short-term scenario will also be that people will be revising their client letters to say, well, 70% was a bit optimistic. We'll, on new client letters, we'll refer to 50 or 60% as a safer bet.
Yes, indeed, and obviously very important given the provision in the CPR that says that if for the cognoscenti it's CPR 46.93 that says if your rates are an unusual nature or amount and because of that might not be recovered between the parties, they're presumed to be unreasonable. So very important. And if guideline rates are going to start being extended into the commercial world for solicitors in doing that sort of work in their retainer letters, they're probably to put into a sort of bold type somewhere, a sort of specific warning about hourly rates. Our hourly rates exceed the guideline rates, and because of that, there's a risk that they won't be fully recovered on detailed assessment. Some sort of specific advice that draws attention to that.
Mm. Anyway, the hourly rates of discussion could go on forever. Should we move on to damages-based agreements and the continuing lack of progress on implementing Nick Bacon and Rachel Mulheron's hard work on some draft regulations to amend them? Yes,
I don't know if you've ever had Nick in to discuss these. There's a particular issue around around that project with he and Rachel Mulheron, which you say it's a great work that they did. But one issue I've never been able to bottom out is the extent to which there was ever any sort of indication, whether formal or informal, that the Ministry of Justice actually had its heart in doing anything very much about this. And certainly there's nothing to suggest that I've seen that it was ever any sort of formally sponsored project by the Ministry of Justice, rather than just something which was, as it were, came from practitioners that could see the difficulties that we're all aware of in these regulations. And you're certainly right to see that I say that there hasn't been the slightest official encouragement, so far as I can see, for DBAs being made more user-friendly. And I, for a long time, had a fairly strong suspicion that the reality is because there isn't a dedicated commitment to them within Whitehall. I think the reality is that there are some stakeholders in Whitehall that have an access to justice focus, and they obviously encourage anything which may involve innovation in how litigation is funded with a view to broadening the litigation base. But there is also obviously also powerful stakeholders within Whitehall that don't want to do things that actually make it easier to sue businesses. And one of the interesting things, and again, this is, which I'm going to say this, hopefully just to demonstrate, I'm not merely engaging in sort of school talk in saying I have these suspicions, but I think there are substantive indications that you can see where there is a debate within Whitehall that's occurring under wraps. Is that when the competition legislation was amended to introduce opt-out collective actions in the CAT, at a relatively late stage, an amendment was slipped in to say that DBAs are unlawful in such proceedings. So you had sort of robbing Peter to pay Paul. On one side of the government was pulling to make collective proceedings easier, and then the other side sort of slipped in an amendment saying, well, you can't do this by a DBA. And I think that's so bizarre. I mean, DBAs are allowed for all other civil work. The things they're not allowed for are things that are, obviously some things they wouldn't work on crime because there aren't any damages. They would work on family, but they're not allowed in family because they would undermine the sort of hypothesis on which family cases work, that you're given enough money to finance your future. And if you've got to alienate it to your solicitors, then it doesn't, the system collapses. But obviously, an opt-out collective action would be a classic big money claim, which would be perfect with the DBA, and they outlawed them. And I think that actually does show you very clearly there is a faction within Whitehall that does not welcome, a new instrument that essentially allows lawyers to speculate on the outcome of litigation, and obviously in some cases potentially get very large returns. So So for my part, I don't think there's any settled appetite at all that has been manifested publicly to make the DBA regulations better than they are. And it's probably as a result of that you are beginning to see like some court hearings, like the Court of Appeal's decision in Zuberi and Lexlaw at the beginning of last year, which are now beginning to take a pretty sort of, tighten your belt and take out your machete and start, trying to clear away some of the undergrowth, which is holding these agreements back, by having some pretty strange interpretations that nonetheless, are beginning to make the regulations look more workable.
And of course, there's a recent case where we don't know the judgment, we don't know the result, in which you were involved in relation to DBAs attempting to bite on what you'd preserved rather than what you'd obtained, if you like, if I can put it that way.
I mean, it was an interesting case, as you say. The first instance, Mr. Justice Zaccaroli, who, for those who don't know him, he's an absolutely fantastic judge. He just held that you couldn't have a DBA that worked on preservation. But interestingly, at that stage, the argument was simply that it was conceded the primary legislation would encompass that, but it was argued that the regulations didn't. Obviously, I'm not trying to mitigate my lack of success, but I mean, since the regulations specifically and expressly refer to the only permitted payment being a proportion of the damages which are recovered, it was a rather difficult argument to say that the regulations did allow preservation. But when we got to the Court of Appeal, the argument went further because the concession that the primary legislation permitted defendant DBAs was withdrawn. I think it's entirely possible the Court of Appeal will say the primary legislation doesn't in fact allow this either. And again, the way the primary legislation works, it does address recoveries. And it certainly is right to say, one would think that you can see that, although in practice a DBA would work perfectly effectively with a preservation, I think you do have to concede that it's difficult to imagine that there wouldn't be a fairly profound difference in the way that DBAs were regulated if they accompanied preservations as well. Because to take an extreme example, I mean, what happens if you do have the sort of crazy, sort of unreal claim where somebody sues you for £10 million? It was never realistic, they end up getting. The case ends up being dismissed altogether. I mean, do you as a solicitor at that point turn around to your client and say, oh, I can have 30% of £10 million? I mean, to that the argument would be, well, yes, if that was what the client was stupid enough to contract for, yes, you can. But you can well see that, it's something that would need to be regulated differently from a claimant setup where, there actually will be a pot of money that moves from A to B, and B solicitor says I'm entitled to intercept a proportion of that which has come into your hands. It is a rather different scenario than where you hold you're simply attacked for a sum of money which may or may not have been a real world risk at the point the attack took place. Or it may be, it was a real world risk, to go back to my 10 million example, it might have been a real world risk as to 500,000, but not a real world risk as to 9.5 million. And again, how do you go about ensuring that the remuneration is connected to that which there actually was a risk of losing? It does, you can see the difference with it, and you can certainly see the argument that within the present regulatory setup, it just isn't something which the regulations anticipate whatsoever.
Yeah.
Yeah, but it's a real concern, though, isn't it? Because if there are real life situations, and you've obviously just come across one where there's a tangible benefit in something being preserved. There's also a tangible benefit in something being mitigated to a level that almost feels like a wig to somebody who's on the hook for a lot of money. I assume there's nothing wrong with a CFA that determines its definition of win or success in that way. So speaking personally, I'm probably not looking at it carefully enough, but I don't see why regulation shouldn't cover that. But there doesn't seem to be much of as we've discussed, much of an appetite to really do the hard yards and grapple with it and decide what they are going to do about DBAs.
Yeah, I think it's right also to say that when the legislation was introduced, no one applied their minds to preservation at all. If you look back at Jackson, you look back at the sort of explanatory notes and memoranda, you look at the parliamentary debates, it just didn't really occur to anyone. And I suspect it's also partly because there probably was a pressure within the markets when it came to bringing claims to allow solicitors to put skin in the game, as it were. And the interesting thing is, I think on the claimant side, they are often popular with the client base and the solicitors. I mean, for solicitors, the potential appeal is obvious. It may lead to, in big money cases, may lead to very large returns. But the appeal to clients is also very considerable, because I think the way clients see it, it's a very simple thing to understand. I'm essentially getting into a joint venture with my solicitor. The solicitor is taking all of the risks. In very many cases, what DBAs I think are leading to in the commercial world is cases being pursued that probably wouldn't have been pursued if DBAs didn't exist. So you're often seeing, there are a lot of DBAs that seem to be coming into existence around alleged sort of false prospectuses and share dealings, for example. Now you're often getting investors who probably wouldn't bother if they had to pay their solicitors in conventional ways. But if a firm of solicitors comes to them and says, I think there's a case here, we'll take all the risk, we'll finance the disbursements. But if you lose, you pay us 40%. Sorry, if you win, you pay us 40%. That's quite appealing to clients. It enables them to litigate risk-free. It's very easy to understand. If the litigation succeeds, they're bound to be the net providers, because if the solicitor's taking 40% or whatever, they get 60% or whatever. And obviously the solicitors have a massive incentive. So it's very popular, I think, with a certain type of client. So I think there probably was real pressure from the claimant market to introduce these things. I just don't think there was equivalent pressure from the defendant side, and it just never got thought about.
Indeed.
Moving on then to group litigation, a couple of cases to look at here. The Supreme Court judgment in Lloyd and Google is obviously a starter for that.
Yes, no, I've mentioned already opt-out collective proceedings in the CAT. For years it's been acknowledged to be by many to be a fault in the English civil justice system, that we don't have any real means of seeking collective redress on an opt-out basis. And by opt-out, just for those who aren't sort of familiar with the jargon. But obviously, since the CPR, we've had group litigation. And in fact, even before the CPR, there was essentially judge-invented group litigation. But group litigation is an opt-in process. The claimants have to be identified, they have to put their names on a claim form, they have to be entered into a group register. And as anyone who deals with these cases will know, even if it's something which is all over the front of the tabloid press, something like the diesel emission scandals and such like, you'll only get a tiny proportion of claimants that ever come forwards. So it's of tremendous interest both to the market but also to those who describe themselves, if you'll forgive the slightly ugly jargon, as consumer champions, to allow some mechanism which actually allows big business to be held to account in a way that doesn't require people to come out of the woodwork. And essentially, to be able to put out an action that says, we have identified that there has been a data leak where, Corporation X, whilst ostensibly marketing a nice free game for you to play through your iPhone, has actually, quietly given itself rights that you click without bothering to read to sort of harvest all of your data and to exploit it. The attraction for just being able to, as firm solicitors, say, we've identified this, we found a person who's willing to act as class representative, and we will pursue this for the world at large. We'll get a fund of damages and we'll distribute it. That's the opt-out. It obviously involves far huger sums because it's everyone, not just those that come forward. And in terms of the sort of initial sort of overcoming the initial inertia to get a piece of litigation going, it's a much easier process because you don't have a book building exercise. You don't need to go out there and find claimants, and you don't have the sort of all the bureaucracy of vetting claimants, seeing if they can be put onto the group register. Do they meet criteria? Updating the group register, putting people on, taking people off, cut-off dates. So all of that is swept away. So it's potentially very appealing. And in other common law jurisdictions, they're either through legislation or on a judge-made process or a mixture of both. These arrangements have come into existence. Now, it's been talked about for years in the UK. The government said that it doesn't support a sort of across-the-board process, but it legislated competition claims, and that's the opt-out collective action, the CAT. Now, the interesting thing about Google, Lloyd and Google, is Mr. Lloyd's representatives identified the much older, goes back to Victorian times regime for representative actions. And the sort of classic traditional way in which you might have a representative action is if everyone has got the same interest and you've got a readily defined class like a group of shareholders, for example, you might find one shareholder to act as the representative, and that shareholder will bring the claim. But at the end of the claim, if the claim succeeds or fails, it's binding on other members of the class. But historically, that was used for relatively small, closely defined classes like a group of shareholders, or something of that sort. Google's Lloyd's idea was to say that in terms of the data breach claim against Google, that you could do the same thing for a far larger and less readily identifiable class, like people that use iPhones or whatever it might be. They failed at first instance. They won in the Court of Appeal and they lost in the Supreme Court. And they lost to the Supreme Court really on sort of technical grounds relating to the nature of the tort. But what is quite interesting is the, and I think it's probably to some extent been passed over by people that don't take a close interest. You just tend to look at the outcome and the case failed. But actually, in the course of reaching the outcome, the Supreme Court did actually make some very encouraging noises about the importance of access to justice and consumer redress. And the potential to use Rule 19, the representative action, to bring opt-out claims, if the right sort of case could be identified where you did have a clear class with a clear interest, where the remedy for all of them was the same. And again, this is part of the concern, was about the remedies. In the Google cases, the argument was that different claimants would have different remedies, different measures of recoveries. And Google attacks that. Lloyd tries to answer it by saying, well, I can just go to the lowest common denominator to limit the cases, either the claims and everyone to the lowest level. The Supreme Court held that doesn't work. But they certainly hold out the opportunity that it would work in cases where generally everybody does have the same loss, which in quite a lot of consumer claims, might well be the position. So it actually does hold out some hope for this. But from the perspective of the sort of people that are interested in listening to a podcast or whatever it might be on costs, what I think is, and this is just given some extremely cursory attention to Google because it wasn't part of Google's challenge. But if Google actually, counterintuitively opens the way, in fact, to some of these cases proceeding, it does, however, then give rise to some very, very difficult questions about how do you involve what you, in the 21st century, you tend to need to involve to bring these cases, which is things like, litigation funding and arrangements like DBAs and CFAs. Because
I thought that was, sorry, I was just going to say that seems to me part of the problem, which is in principle, it's quite simple to think of a solution where using the representative procedure, you get a declaration that something has been, some right has been infringed, but then you need the second stage to establish the damages in this situation. And the problem with funding arrangements, nobody's going to fund you through the first stage, which is perhaps quite an expensive stage, unless they can be guaranteed a recovery. And the problem is they can't. Of
course, it's here, and I think, Simi, the brick wall you potentially run into is it's obviously in the very nature of an opt-out scheme that the individual claimants themselves, so I say claimants, I actually mean the members of the class. They're not claimants. That's the whole point. They obviously have no relationship whatsoever with the solicitors or the funders or the AT insurers, whoever it may be. But the solicitors and the funders and the AT insurers, how do they get remunerated? Well, in terms of the solicitors' basic charges and the basic disbursements, so obviously if you win, you'll get them or most of them back from the other side in the usual way. But what you obviously can't get, post-Jackson, you obviously can't get, if the solicitors are on CFAs, you can't get their success fee. DBAs don't work at all because the DBA obviously takes a percentage of the damages, but the only party to the DBA will be the class representative. Now, in most of these cases, if they're data breach claims, for example, the individual damages, they might be £1,000, they might be less, they might be more. But so under the DBA, under DBA regulations, you're limited to taking 50% of the damages. The only person the solicitor has a contract with is the class representative, so they get 50% of £1,000. Well, obviously that is hopeless. And litigation funders, they have precisely the same problem. You obviously, the class representative has got no power to contract to agree that all of the other members of the class, when they come out of the woodwork and say, yes, please, I'll take my £1,000, to say that they have to, give up 30-40% of it, whatever it may be, to the litigation funder. So again, you have it's a privity of contract issue. Everything, and it's a paradox. Everything that makes it attractive is its opt-out nature, but the opt-out nature makes it very problematic for funders, whether they be the lawyers through DBAs or CFAs, or if they be external financial institutions through litigation funding arrangements, to sort of to work out a mechanism by which they can reliably get a reasonable share of the money in order to compensate them for the risk they've taken and the funds which they've advanced. Now, there are particular arguments. I mean, in the US, for example, there's sort of fairly developed principles that charges can actually be deducted out of the damages before they're distributed to the class. And in other countries, you get that through legislation. For example, in Australia, there are sort of detailed rules of court and so on which deal with these issues. And in our country, we have that in the CAT. The CAT has come up. The CAT rules have a mechanism by which all the funding charges, you can claim them out of any damages which are undistributed, and and they can be paid out of that before the undistributed damages are then. I don't need to go into the detail, but in essence, if you go to trial and lose, unclaimed damages go to charity. If you settle, you can actually say that unclaimed damages go back to the defendant. That's why there's a huge incentive on defendants to settle these cases. But that all results from primary legislation, so you've got none of that in Part 19. So the situation that we are left in is that, in fact, as I've said, counterintuitively, Lloyd and Google actually encourages some of these cases to go forward. The access to justice arguments, which the Supreme Court endorses in Lloyd and Google, are very strong. But you then run into the fact that you are ultimately trying to shoehorn a sort of slightly ramshackle 19th century procedure, which has clearly been devised for a completely different sort of litigation, into an opt-out collective action, which only works if you've got sort of third parties willing to put up money and take risk. And then the question is, but how on earth do you get those third parties to get a reasonable return out of the litigation at the end of the case? And the reality is, you can see routes to judge-made law that would answer that. But, the difficulty then comes is, but, somebody's got to put their heads above the parapet and ask the judges to make that law. In circumstances where, I think everybody involved would have to acknowledge there's a risk. The judge would say, well, no, it's just a step too far. This is a great idea, but you need legislation. And, if the judges are only willing to answer that at the end of the case, you have potentially got funders who are millions and millions, risking millions and millions of pounds, not just with the conventional risk that we might lose, but with the added risk that we might win and still get absolutely nothing or close to it. So, again, one of the, I think, sort of $64 million questions, maybe literally $64 million questions in these cases is, will the courts agree, maybe a bit like in a BEDO application in a trust case where the trustees apply for sort of for a regulation of their cost recovery at the beginning of the litigation. Will a court be willing to say, perhaps motivated by the access to justice imperative, okay, as part of the question as to do we let this representative action proceed, we will also, as part of that, have a preemptive decision as to whether there is any legal mechanism by which funders can get a share at the end. And it might be that question can be answered at a cost of hundreds of thousands of pounds rather than millions of pounds, and there will be a funder who is willing to explore it. But that at the moment seems to me what is going to be the impediment to this, as I say, extremely imaginative attempt to create a sort of common law collective action. It will actually won't be at the dog end, it will be at the tail end. It will be, how do you get the funding and such like to operate when it is an opt-out procedure?
Yeah. Well, looking though at the CAT, there was a decision of the CAT in the FX litigation case, which did that surprise you or contain much of interest, do you think, generally?
The FX case was ultimately turned on the competition law aspects. And it was an unusual case in that there wasn't an argument as to whether it should be certified. There was an argument about whether it should be opt-in or opt-out. And if it's opt-in, it's a crude way of putting it, but that is broadly analogous to a group action in the courts. So you have the book building exercise and all that other sort of red tape and inertia that needs to be overcome before you get off the ground. And as I understand it, I'm involved in the case, but as I understand it, both potential class representatives have said no. If it's opt-in, it just won't work. And the tribunal held for competition law reasons it's more suitable to be an opt-in claim. I understand that's going to be subject to appeal. I think from our perspective, as again, for people watching this, listening to it, interested in costs and funding, the more interesting aspect isn't so much the non-certification of the opt-out, but it's the first case to come to court where you've got two rival class representatives. You've got O'Higgins and you've got Evans. So Higgins gets in first, Evans gets in second. Both got very, very competent legal teams. No one is seriously suggesting that one side is sort of inept and the other side is skillful. They're both formidable, formidable legal teams on both sides. How do you choose between them? And I represented the Evans claim, which the tribunal said, well, if we had certified one of them, it's Mr. Evans would have certified. So it was obviously gratifying to win that. It's fair to say that they said it was very close, but more to the point, and I hope I'm not saying anything that would upset either people on my team or on indeed the O'Higgins team on the other side. I suspect they would sort of wearily nod their heads in agreement. You wanted to have the sense of the old saw of the circular firing squad, in that there were the defendants just sitting there neutrally, whilst you had two claimant camps, each arguing that they were the better, and probably spending as much on that argument as needed to be spent in order on the separate freestanding certification arguments where the defendants were active. So essentially the case split into two, and 50% of the case was two rival claimant camps attacking each other. Now, in the course of that attack, there was a great deal of focus on the relative funding position. And in fact, I think the tribunal essentially held, well, both sides had good funding packages. You could favour you could make points in favour of one, favour of the other. They're very clear, I think, that you can't just go off and buy £100 million of ATE and thereby win because your opponent's only got 10 million. You can't just buy it. It's a question. It's not just. It's about quality. It's about need. You don't buy 100 million if you only need 35 million. But there was a lot of attention on this, and again, it was interesting to see, and it was, and again, almost this sense of the circular firing squad, because obviously, on both sides, AT insurers came in, they offered their services to one of the camps. But it was also perfectly clear that if one of the camps failed and the other one succeeded, the AT insurers who had initially supported the other camp would have been only too willing to come over to the other and start saying, well, if you need some top-up cover, we're available in the market. So it's a very curious, it's a curious scenario. It does, I think, give rise to difficulties. One assumes that in a lot of cases it will essentially become self-solving, because the commercial incentive on the sides to sort of pool resources, may often prevail over, having the fight. But clearly it won't always prevail, because it didn't prevail in the FX case.
Can I ask you a technical question in relation to that question of which was the better person to allow to proceed? They looked at costs and they looked at liability for adverse costs. And I'm just reading, I think it's my summary rather than the quote. It was said, if the representative has proper provision for payment of the proposed defendant's costs, the representative should not consider themselves at risk of personally having to satisfy a costs order unless there was misconduct or something like that. And it said the risk of such an order would have a chilling effect on the collective proceedings regime. Has the indemnity principle been disapplied in this area? I mean, I appreciate that the members of the group, if you like, other than the representative, can't be made liable for costs under the rules.
Yes.
But in the situation of the representative, surely the representative has to be at least notionally liable for costs for the indemnity principle to be satisfied, or has that also been disapplied and I haven't seen it?
I mean, I think it's fair to say that is something where the tribunal was shooting from its hip rather than it was really, anybody had really sort of canvassed the issue. I think that, I mean, I from memory, Marcus Smith, Mr. Justice Marcus Smith, the president of that particular tribunal, did, canvass that during argument, but it wasn't really picked up on. And obviously the commercial expectation in these cases is that the funders pay, or the AT insurers pay. But I think the proposition that the cost, and of course he was talking about adverse costs, not liability for own costs. But I think the proposition that the class representative isn't at least theoretically liable for adverse costs, is a difficult one, not least because, as you say, the rules essentially say that they are, it's the other members of the class that aren't. The expectation is they're indemnified, and they would be extremely badly advised not to be indemnified, given the level of cost in these cases, but they are themselves on the hook. And certainly for their own costs, certainly my understanding the indemnity principle still applies, so they do have to be theoretically liable to pay the solicitors and indeed the funders. But unsurprisingly, the arrangements, if the class representative is well advised, will usually be non-recourse in nature, so that although they are liable to pay, for example, the solicitor under the CFA, the solicitor undertakes that the only entities to which they will look for payment is either the funder or the opposing party. So and similarly with the litigation funding, obviously the litigation funding will commonly expressly provide that the only source from which the funder can take its share will be the undistributed compensation, which, as I say, is the way the CAT and rules anticipate it will work. Funding will be discharged out of undistributed damages.
Yeah. Andy, any thoughts on any of this?
No, I'm really grateful for for that sort of review, and I mean it's troubled me always really about any form of opt-out that it creates even an even larger distance between the client and any type of control over costs. I mean, to be frank, in group actions, it's pretty illusory anyway most of the time. But costs seem to be self-generating, and there doesn't appear to be a lot of appetite in the CAT to control costs in any form of budgetary sense as they go along. potentially other than at a very high level. But perhaps we're too early in some of these certified cases to know actually how that will work out. But,
yes, I mean, of course, because these opt-out actions were all put on hold pending Merrick's and MasterCard in the Supreme Court. No, they are really only just beginning to get running. You know, obviously, and now there are a lot of them, and certainly, I think they're going to give rise to lots of issues. I mean, said that I act for Mr. Evans in FX. Obviously, the two unsuccessful applicants, so Higgins and Evans, are now facing claims for the bank's costs. And you know, every single bank has gone off to its own city firm with its own counsel team. And as a result of that, a 5-day hearing, interlocutory hearing, for which I think nearly half of it was given over to the carriage issue between Higgins and Evans, on which the banks were neutral, where the banks served no evidence of their own, called no expert evidence of their own. So they took their response was entirely limited to legal submissions and picking apart the claimants' evidence rather than anything. So I think that cost £15 million. Now, you know, obviously there are going to be in due course huge arguments about duplication and such like. You know, if no one suggests there was any conflict of interest between the banks, now obviously they're each entitled to go up and get their own firm of solicitors. But it's an non-sequitur to say, you know, just because you're entitled to your own firm of solicitors, that means that, you know, every firm can be there active at the hearing, you know, with its own counsel team. Obviously, very serious arguments that you know, where there is no conflict of interest, you know, just as you would in a group action, you have a lead solicitor and with a single counsel team. You know, so I suspect, you know, this world is going to give rise to some exotic, all sorts of exotic arguments about funding. So, but we're also going to have like common or guard and detailed assessment questions like duplication, but just on a canvas which is infinitely larger than canvases which we've previously seen. You know, simply because of the massive scale of these cases and the stakes for businesses. Yes. And you can see why businesses want to stop them. I mean, as I've said, if they get off the ground, the incentive for businesses to settle, because if they settle, they keep the undistributed damages. And I mean, I'm told that from experiences in the US and Canada, I mean, it's truly remarkable if 50% of the damages get distributed. And in many of these cases, it's sort of 5 or 10%. So if you have a business that knows, well, if it settles, I potentially get 90% of my money back. Now, I mean, you know, it's a huge incentive on them to settle. So you can see what they actually want to do is they want to strangle these cases in their grave by opposing certification, because, you know, once you've got certified, you know, the commercial pressure on the business to settle is huge.
Perhaps people will start setting up firms to go around advertising for people to claim their unclaimed damages for a share of those.
Well, yes, as we've seen, there's now an entire industry in the personal injury world that goes around attacking what personal injury solicitors have deducted as success fees. Now, I don't think it's fanciful to suppose that there might be, you know, there might be other areas where that business model gets built on. You know, it would be unwise, I think, to think it would just be the poor personal injury solicitors that are subjected to these shakedowns, you know, forever. I suspect, you know, it may very well be that lawyers and funders, you know, do potentially face, you know, similar questions. And you do get, because I mean, like, obviously, I think notoriously in the post office litigation, the postmasters, I think they lost, and mistresses, they lost 85% of their compensation. Now, I'm not suggesting for a moment that's because the funders were unreasonable. I don't know the details of it at all, and clearly it was a very risky case. But again, I think it also exposes something that is very wrong in our system at the moment. You know, and I think it's universally regarded that the post office, you know, behaved disgracefully in that case. And I don't just mean in the events that gave rise to this case, but in the litigation itself. Yeah. You know, running it incredibly aggressively, you know, taking every conceivable delaying tactic. That, no doubt, is why instead of the usual sort of 30-40% deduction from damages, there was an 85% deduction. Very troubling that the court doesn't have any power to require, you know, where you as an unreasonable opponent cause your impecunious claimant's funding costs to increase very substantially. That there is literally nothing by which you can do as a court to force them to contribute. You know, unless it can be said, and this would be entirely new law, that you may not be able to recover these charges as part of the cost order, but can you recover them as part of the damages? That, I think, is not an issue which has yet been argued.
No.
But difficult to imagine But of course, we're suddenly going to say, oh, well, we may have stopped you recovering success fees and such like as damages, as costs, but now you can have them as damages instead. But then, to show the lack of connected thinking in these cases, for many years, people listening to this, they might sort of vaguely remember their first term of contract at law school, and they remember there was a famous old case, or notorious old case called the Lees-Bosch dredger, that said that if you can't, if your losses are increased because you don't have the means of mitigation, that's too remote, you can't recover it. And in 2003, the House of Lords overruled that case and said, no, I mean, if it's foreseeable that people who lack means, may have larger losses than people that can immediately go out into the market and sort of buy in services that protect them against, the position the tort has caused them. Of course they should be able to recover it. So, in that area, you've got suddenly impecunious people, they can recover the extra losses which they're caused. On the damages side, whereas at the same time, a few years later on the cost side, we take that away from them.
Yes. I mean, yeah, exactly. I mean, there are, stretching it a bit, but I mean, there are some sort of funding costs, including pre-judgment interest, that you can get either as costs or damages.
Yeah, quite. I mean, that is true. Pre-judgment interest, of course, is a significant factor. Again, there's a mystery to that for me as well, in that the business and property courts routinely award it. So, you get your big blue chip companies who are the commercial courts customers, they get their sort of interest at 2% above base or whatever it may be from the date they pay their solicitors. But if you represent a claimant in a PI case who's maybe taken out a disbursement funding loan, you try to get the interest back on that. In my experience, the cost judges absolutely without fail find a way not to award it.
Exactly.
And so you get the suggestion of poor Mrs. Jones, with her sort of broken leg after a car accident, may lose thousands of pounds to her disbursement funder, whereas Barclays Bank PLC in the commercial court, which paid Herbert Smith £100,000, 6 months ago, it gets interest on that. It really is a very, very strange state of affairs.
Exactly.
Well, Ben, as usual, your incisive analysis reveals a series of paradoxes which apply in the way the law is administered today. But thank you very much on behalf of Practico and all those who are going to watch this for participating in the discussion. It was, as ever, very, very interesting. A piece of good news for those like me who used to enjoy a bacon sandwich in the City of London before these things went virtual, is that Practico is planning to revive the physical meeting somewhat later in the year, but I'm sure news about that will come out later. On that note, thank you very much for joining us, and it was a really interesting discussion.
Thank you.
Thanks. Pleasure to see you both.
Thanks, Jeremy.